And we'll kick off with a karakia, James.
Mā te whakapono, mā te tūmanako, mā te titiro, mā te whakarongo, mā te mahitahi, mā te whakamomori, mā te aoha, ka tia ia mātou, by believing and trusting, by having faith and hope, by looking and searching, by listening and hearing, by working and striving together, by sheer desire and determination, by being done with compassion, being specific.
Thank you very much. Marina, and good morning to everybody. My name is Bill Smith. I'm an independent chair of the hearings panel today. On my left, I've got Councillor Steve McNally, who's also a hearing commissioner. And then on my extreme left, I've got Alan Watton, who's an independent hearing commissioner. Our role, we've been appointed by the council to consider the submissions on these topics, which are renewable energy, infrastructure, transport and designations. And in your case, I think we're dealing with designation. We have read the section 42A report, we've read the submissions and all of the evidence that's been pre-circulated. So we've got most of that in front of us. The section 42A report, imagine Mr. McPhee's possibly explained to you, is just a recommendation to us. Once we consider all the evidence and before us, we then, the officers get a chance to have a right of reply, so their recommendation to us may change, it may not. And then once that's finished, we then sit and deliberate and decide whether we accept the recommendations or whether we prefer the evidence that's submitted, possibly, or whether it should be tweaked. So that's our role. Is anybody good? Yep.
Who actually prepares my the 42A report?
Well, this officer, yes, so I'll get them to briefly introduce themselves in a moment. So the officers do that, so they're expert planners.
Yeah.
So that's what they do. So they would have read the submissions and everything. They would have read the legislation that applies to the topic that they're dealing with. And then they write a report. That's what they do. So have you got any questions about the procedures? No.
It's important to realise, just through you, Bill, it's important to realise the officers make a recommendation to us in terms of what they think should be done, sort of stuff. But it is a recommendation.
Yeah. All right. Housekeeping matters. I'll get AK to do that.
So the toilets, as you've just found, are to your left and then left again in the event of a fire. This is our only exit, and we'll head out the main entrance if we can and assemble out the front on the grass. If everyone can just make sure they've got their cell phones off, and we are recording today's session and it will go on later for everyone to view.
The only other thing I need to point out to you, as a result of a question from the panel, we were given a letter dated the 7th of August 2023, which was a letter that was sent out to those landowners, or some landowners, or whatever, advising them about the critical electricity line. So that's a copy, and there is a copy on the website.
Correct.
And the other thing we asked for was a copy of what was in the Whangarei District Plan. So we've got those two documents in front of us as well. So just so you know that they have been tabled to us as evidence. So now what I'll do, I'll get the staff to introduce themselves. So AK is briefly.
So Morena, I'm AK, the Hearings Administrator in the District Plan team.
James Witham, Team Leader, District Plan.
I am a policy planner and I wrote designations.
My name's Jerome White. I'm the reporting officer for the structure text.
Which is the chapter that I think you're here for today.
It's just online.
In Kenton.
Kia ora koutou, Kenton Baxter, Policy Planner, Reporting Officer for the renewable energy topic.
Thank you very much, Kenton. So we have a number of submitters today, so I'm not sure whether you're representing everybody, Mr. McPhee. I know there's Wiramu Tane. Is Wiramu Tane here? Okay, thank you. Mario Ohio.
Correct.
Yep. And Aaron Simpson.
Correct.
Okay, right. So we're open to you. We'll let you lead on.
So perhaps I just run through a summary of my vetting evidence, and we'll let the landowners provide some lay evidence and present to you after that. So good morning all. I'm here on behalf of the Oromoho landowners. Submission 131. As you see it, understand my evidence, it's taken as read, but just to summarise. In terms of the 33 kV lines, the Section 32 report talks about critical electricity lines, but nowhere does it state what they are or what they include, other than say the overlay ensures a resilient electricity distribution network in addition to those rules particularly the national grid. Section 32 report does not justify or address the inclusion of 33 kV lines for the CEL overlay. Additionally, no evidence has been produced by Top Energy to justify the inclusion of 33 kV lines as CEL, or the treatment being the same as 110 kV lines for the CEL overlay. No analysis has been provided that I've seen identifying or justifying 33 kV lines through the criteria recommended for the definition of CEL in the Section 42 report, yet they've been included in the definition of critical electricity line overlay definition. It is difficult to find a pathway through council's planning documents suggesting that it was council's intent that 33 kV lines were to be included. The PDP being notified. So in summary, I'm of the opinion that no justification has been provided to treat 33 kV lines the same as 110 kV lines within the provisions of the PDP. Recommended inclusion of a definition of CEL is problematic insofar that it's not easily discernible which of Top Energy's lines fall within this definition, and the subsequent recommendation to include a definition of the CEL overlay, including 33 kV lines. That's appropriate evaluation to do so. The proposed new definition for upgrading does not add anything to the interpretation of the infrastructure chapter, in my opinion, as there is no quantification of scale or intensity. The proposed 32 metre buffer for the CEL overlay in the subdivision chapter is inconsistent with national regulations and imposes unnecessary land use restrictions. Existing regulations under the NZECP 34/2001 and Electricity Hazards from Trees Regulations 2003 provide sufficient protection when appropriately referenced within the provisions of the PDP. In principle, the district plan should not be regulating something that is already regulated. Top Energy already has the ability through legislation to operate, maintain and upgrade regionally significant infrastructure. A decision is made to retain 33 kV lines within the definition of CEL overlay, then the recommendations proposed in the 42 report for IR12 and IR13 are supported. And the recommendation proposed in my evidence for subdivision R10 are supported as a controlled activity. And I'm happy to answer any questions once made on the
Okay, thank you. And I can draw you to paragraph 28 of your evidence, Mr. McPhee, where you outline the not 28, sorry, paragraph 23, where the officers have put in what's in the RPS and to justify the CELs. Now, you've said that you don't believe that the 33 kV line comes within there, but if you have a good read of that.
So 23 of my evidence.
Yeah. So the definition there of CELs, and it refers to supply essential public services such as hospitals, civil defence facilities, etc., etc. You don't believe any of those things apply to the 33 kV line?
No, I'm not saying that. What I'm suggesting is no evidence is being provided suggesting that the lines identified on the overlay meet those criteria.
So if
I simply don't know. I couldn't tell you. But I haven't seen anything to suggest that they are all fit within the criteria.
if they did meet that criteria, would you then accept that they should go into the district plan?
Well, yes, if there's a definition that states that, then there's no option.
Yeah, because we've got to follow the RPS or high order documents.
So the definition that's proposed, seems to have come from the Whangarei district plan, not the RPS.
No, it draws on the RPS. That's my understanding.
It draws on the RPS, but
yeah.
It's basically drawn from the CEL chapter in the Whangarei district plan.
Okay. Any questions? Yeah. You want to go for it?
Yeah, so my understanding, you're saying the 33 kV lines, there's no justification for mapping them in the proposed plan.
we're not mentioned anywhere in section 32 or section 32 analysis of valuation.
Okay, unnecessary land use restrictions such as,
Well, it's over and above national regulations. So
that's my next question.
Right.
It's already regulated by the legislation. What legislation?
the NZ-ECP 34/2001, which controls distance from transmission lines and structures.
What
And
about,
it's referenced in the law.
what about the fire service regulations? You know, a lot of district plans refer to fire service regulations and the like. Could argue that they're provided for outside of the district plan process, so I do it through the district plan, but be that as it may, most district plans pick up on them.
That's a good point. I guess it's what's being proposed goes over and above what those regulations are controlling in terms of setbacks. So it's unclear why there is a necessity to go on over and above national regulation.
Yes, sir, interpret.
That's all right. Now, I've asked that same question of other submitters, you know, what's the legislation? And so that's a New Zealand electricity something or other.
Yeah, it controls setbacks.
Yeah.
From transmission lines, it's for health and safety.
Yeah, I know exactly what it says, but I just wanted to, I've asked everyone, and thank you.
So you've got the Electricity Act too, which I think enables public energy to go on to take the risks.
Yeah.
Steve's asked everybody and realises that he knows more than they know anyway. So is there any point in mapping for information purposes? Like there's a number of things in the plan sometimes that are mapped for information purposes, so that if people are looking at land acquisition or land purchase or the like.
I think that's stated in my evidence. You know, it's always good to map something which is being controlled.
Yeah. So what are the practical implications of the setback? What are the limitations on the farming activities or the like?
Farming activities not so much. What's being proposed in the 42A report for a higher 12 and higher 13 seems practical, and I agree with the report. Subdivisions a little bit different. I don't understand the necessity to go over and above those land use controls for subdivision. We demonstrated that you know, buildings or structures can be placed within the same distance from that infrastructure.
Yeah, so that's the final paragraph of the evidence, isn't it?
Sorry, which paragraph?
Well, at 67, I think it's the final paragraph.
Yeah.
I always put some stars at the bottom of it so that nobody can read anything in there that I've never written. Yeah. Right. Yes. Anything else?
No, listen to the rest of them, please.
Yeah.
Do you want any points of clarification? Are you all right at this stage?
Just to note that those criteria, they are from the appendix 3 of the RPS in terms of regional infrastructure.
Index 3 of the RPA.
And also just to reinforce that the rules aren't intended to go above what's in the ECP, they're just intended to reinforce compliance with that regulation. It's sort of just act as a trigger for compliance with that regulation.
Well, statute, in the statutory sense, they can't go beyond what's in the RPS, can they?
No.
Thank you. Do your other witnesses, other folk, have anything to say?
Who wants to go next? Is it, we remove Tony, we've got you next, but you can go and edit whatever order you.
Sorry, so good morning.
Good morning.
And good morning. I didn't realise that was you.
Oh, good morning.
Thank you for helping us with the organisation. So we had a group presentation on behalf of the Maui landowners, which is lay evidence. And so we're going to, the three of us will present that, but we also are individual submitters for our own organisations as well. So if you're happy for us to do the first presentation and then following this, we'll conclude and we'll present individually.
The comment I've got to make as well is that you asked sort of any comments to make in relation to Andrew said. Some of those questions that was asked of Andrew actually covering what the evidence.
All right, okay.
So I don't want to double over. And then in particular with to do with the 4 criteria, for actually identifying the poles, or actually igniting the regional policy statement to state that.
Now we're here to listen.
Oh, yeah, there'll be plenty of it.
That's good.
Especially, tuatahi ka haere tonu ngā whakamome ki whakawhetai ki tō tātou matu no te rangi. Firstly, I want to acknowledge our Lord that presides over us. Kami ia te ohi ki te au ki a koe e kara. Nau i tuku te whakamome ki today. Your pai uki tō tātou no ki rau tui ki o te whare. But to you, sir, thank you for delivering the trakia on behalf of us all this morning. And to make us warm and comfortable in terms of our meeting here today. Kami hea te hoki ki te haukainga, te iwi o te raroa, so it's customary to also greet the local iwi, and I do so accordingly. Me o tātou tini mate, and also our many bereavements that happened over recent times. Today is an opportunity for us to e kaue ngā mate mai te kāinga I konei, ki tū hono a rātai waipu. So all those that have deceased over these past weeks and days, which have been many at home, we bring here today to greet and mix with the spirits of the local iwi here, bearing in mind all our deceased persons. Spiritually, we say, head to the kapowai rua e te rei. Reira, tēnā tānu katoa. Ko paue rua, me taratara ngā mauna. So those are our acknowledged moments from our area. Ko te waiaru he, Manaya, me Waitangi ngā awa. Those are the three rivers that run through our area of the influence. And we say, mai Poirua, from our Mauna Poirua, where basically Ngāpuhi was born, to Ngātau Mangamama, which is Cape Breton, is our area, tribal area of influence. O ngā hapu, ko Ngāti Kawa, o te Ngare Hauata, Matarahurei, Ngāti Kaipō, te whānau rāra, Ngāti Rahi, mai te whai o, ki te ao māma, ki hei mauia. My name is William Tane. I'm the chairperson of the Ōmāhui Farm Trust. I'm here this morning at this particular time to introduce our collective group. On my right is Mrs. Erin Simpson, Mario Kaitāia. Behind me sitting are Gary Stenners, Stephen Boys, and not present today is Errol McIntyre. The group was basically formed at short notice in what has become a complex issue to pose top energy submissions to reclassify the 33 kV lines to the same status as the critical energy lines in the proposed district plan. We are here collectively today to present our lay evidence. Thank you very much for receiving us this morning.
Just pick up just before. So as you can see, our collective has 239 hectares of land down in Ōmāhui, and on that land we have 17.45. These are estimates. 17.45 kilometres of 33 kilowatt lines. So you can imagine the setback on that multiplied by the distance of the lines is quite quite a significant amount of land. And they'll be constrained.
So it's my turn. All right. I've got some notes here, so.
Can I, Mr. Simple, once you finish reading your notes, is there any chance you can give a copy to AK when we'll have our break? We'll get a written copy because we can't write verbatim. It's just good to get your notes so we can refer to them. Thank you. Carry on. Sorry.
I'm starting with the background and interpretation. Yeah, on our original on the submission we sent in. This has been actually a journey for all of us. It's been a major learning curve. It's been extremely taxing. Because we're laymen, obviously. And put a lot of effort into it. And as is going to be pointed out, yes, legally it was proper notification, but to us it was insufficient. And we objected, which is what our objections are mainly based upon top energy. We should have been sort of angling at the council as well, because that's why we're objecting to the CELs. But anyway, before we get started, what is stated in our submission in front of us is we view legislation, and its interpretation. What is highlighted on the screen in our opinion points out that 30 kV lines and possibly 110 kV lines in the far north area should be not identified as reasonably significant infrastructure. In particular, well, no, be with top energy and not mapped to CELs, as they do not qualify to be treated as such. It is very clear from the screenshots that national policy statement on electricity transmission was intended exclusively for the national grid and Transpower, and to be recognised in the district plans via the regional councils, RPS. New Zealand policy statement on electricity transmission has no relevance to justify the inclusion of top energy in the district plan, especially with their ad hoc suggestions, as they want to use as a benchmark. The regional council and the RPS has also no justification or clear reasoning to directly instruct the local councils to identify local distribution network lines, in particular 33 kV lines, as regionally significant infrastructure. And I refer you to the reference 5.3.5b on the screen. It states there may be value. That is a suggestion, and there's no clear rationale behind it. This is why, in our opinion, Far North District Council and the PDP should never have included top energy lines in their map overlays. This is stated in top energy submission point 483.39, which Mario will put up on his screenshot when it comes. And it's very, very clear what's going on. In fact, they canvassed the Far North District Council to do so, as we believe the Far North District Council could see no clear directive or justification to do so from the NRC. Yeah, as in reality, it was a suggestion, not a requirement. But before I hand you over the next two screenshots, can you run them up, please? This is an answer to what Andrew was questioned about those 4 points. If you look at that map clearly and closely, you'll see that top energy have actually designed a very resilient infrastructure. Every town in the far north is surrounded by two 33 kV lines. The only town that is not surrounded by that is Kaitāia. If you look across our particular area, which I'll outline in my final submission, you'll note that there's 2 lots of lines running through our properties. You find they're very obtrusive, what's going on in there, but I'll cover that later on in my final lay evidence. So to me, that is a very resilient infrastructure. And I agree that the 110 kVA should be mapped, which is owned by top energy. because that's a major feed line. Then if you look across to the left-hand side, that line distribution network disturbance is what Top Energy has actually provided in their original submission. The yellow highlights are pointing out, which I'll follow by the map, have nothing to do with 33 kVA lines. The ones which are not highlighted, we don't know, they are questionable. Top Energy, in my opinion, has actually been misleading with their evidence. So I'll give you a chance to examine that map and you'll see what I'm talking about. And that is actually an answer to one of the questions that Andrew was asked. It's extremely resilient. And I can testify to that because the 33 kV lines obviously go across our property and I've never known Top Energy to be out there repairing them. The only thing they've ever done is actually do maintenance, and we've allowed them to do so. And there's been zero restriction put upon them by anybody in our area. And that, in a nutshell, is why we're so upset about it. Yeah. So, yeah, if you want to examine the first slide, if you can run it back up again, please. Yeah. If you look at this, the square box at the bottom, this is actually from Transpower's submission, the original submission. It states there clearly the MPSET only applies to the national grid. The assets used or operated by Transpower are not to be included in distribution networks or words to that effect. So really, from my eyes and our group size, this whole thing has been derived from a policy statement on electricity transmission, which was issued by the government. It was then handed down to the regional council to put into place. And the whole thing is not, there's no justification to actually do it with 33 kV lines in our area or district plans. It says in here, in the other box, there may be value in including other regional specific net structure on the district and the regional planning maps. So
There may be.
they are not quantifying the distribution lines, and they're saying there may be.
It's not a direction.
Yes, it's definitely not a direction. So looking from a layman's point of view, the whole thing is being derived from the Resource Management Act, Section 2, being an interpretation, and then the government has put a policy statement through. It's been followed by law, which it should be by the regional councils. It's been misinterpreted and a non-direction's been taken, and then it's been handed down to the district council to implement, and this is why we're actually here now, because it shouldn't be there. And I believe the district council had no intention of putting it in the first place. And that's actually in Top Energy's submission, which I'll get to run up now, please.
Really?
Yeah, well, no, we'll leave it for Mario, but you can read it when it comes up. It makes very good reading, trust me.
Yeah, so you just got the point about the yellow highlights there.
Yep.
So there's a list of probably 6 properties that they've had line disturbances on. And of those 6, there's no report on what that disturbance was and whether that and whether they are 33 kVI, the critical lines or not. But that's the only rationale we can find for the inclusion.
So it appears to me that it's not really, the line's not at risk, not an issue. And that information, dare I say, is actually misleading.
Okay.
Yeah. So I'll let Aaron continue because highlighted there in yellow is what he was referring to in Top Energy submission where the lines weren't initially meant to be included, and then as a result of Top Energy submission, council took it upon themselves to notify nearly 12 months later on the PDP regarding the top energy lines. You want to comment any more there? If I carry on?
No, all actually, well, so as I stated, the district council had no intention of putting them in the first place because, there was no rationale behind it.
Top energy seats that this be extended to include
Yeah.
33 kV lines.
So if you read it, they went back to the council. The council then included 110 kV lines. That wasn't suitable, so they went back to them again and canvassed them to put 33 kVA lines. And then on top of that as well, they've taken the ad hoc sort of approach, picked up Transpowers statutory legislation and restrictions, put it on the end of it. It's totally wrong.
I'm listening to what you're saying. However, the letter dated the 7th of August 2023 from the council, and this is a council letter that I referred to, which I take it some landowners got it and possibly some didn't. I'm saying some didn't.
I'm going to get on to that.
Yes.
Yeah, but if you read that, I'm just saying if you read it, it says the new provisions were intended to protect all the district's 110 kV and 33 kV electric lines from inappropriate development. So that's the council saying that, not Top Energy. So I'm just reading what the council letter says.
Sorry, what's the date of that? Is that the letter that went out to?
I can show you because
Yes. Never seen it.
I might have some more copies here.
we've got some more copies here for you. So
Yeah, so that's a statement from council saying. Thank you. That's that one. Yeah, so those of us that were fortunate enough to get this, because I've got this is all they got.
I haven't
So
written that.
that is what a lot of our landowners got.
Okay.
It doesn't mention, it doesn't delve into details. All it says, and this is probably brings me to the slide. It says there was a GIS mapping emission.
Yeah, that's what it says.
Yeah, that's all it says in here, and that you may be affected. Now, if it was never intended to be included, then that's untrue. Because, and what is a mapping emission?
Yeah, but okay, we need to have, if you get a chance, we'll let you copy that. But I'm saying this is a letter that we asked for. What was the letter that was sent to those ratepayers who got it? And I accept that some maybe didn't, right? But in it there, it's clear that this is the council letterhead. It's from the council to people. And it says that it was meant to be in.
This is what they got.
So you're saying nobody got this letter?
No, well, I didn't get it.
Yeah. I'm not saying you, but nobody at all got this letter.
Can you point out?
Who?
Can I ask every single man?
No.
No, I'm just asking.
Yeah,
No, we didn't get it.
Gary, you ever seen that before?
No, I've never seen that.
No, I haven't seen it, but I just got one little comment to make here.
Yeah, I'm just,
I just got one little comment to make here. It says, unfortunately, to a GIS mapping error. Can you tell me that nobody in the council proofreads anything before it goes out?
You'd have to ask yourself whether the council has made other errors than anything. It's either they make lots of errors.
Yeah, I know they're making an error of this.
Any council does.
Yeah.
But sorry, Bill.
Go on, carry on.
There seems to be two parts to what you're saying, or two parts of the concern. One is the council's actions in terms of notification and whether people were notified in the way that they maybe should be or the like. But at the end of the day, even if your case is that it hasn't been done correctly, the council can just run through that process again if they wish to.
Yeah.
They can reinitiate that and you'll be back here again.
That's right.
But the other part of it, which is probably more important from our point of view, is the impact that overlay or the like has on your particular properties, and is that a reasonable imposition on the properties or not? But I think you can spend a lot of time. I mean, quite honestly, it sounds colloquial, but we don't really care whether we're not going to make a ruling if the council's acted improperly or the like, because
Yeah.
At the end of the day, that doesn't really bear too much on the substantive decision we've got to make about, you know, the submission that
They're trying to make it.
Yeah.
You're
I
trying to
mean,
make
most places, I mean,
Well,
various ones of us get involved in these things around the country, and everybody points to finger at council.
quickly.
Yeah, no, that's, you don't have
Another
to
point is taken. I'll just make the reference really quickly and we can move on to what you're looking for in terms of impacts on our property. Because some of the stuff we are talking about is it's process stuff. And that's I'm surprised the commissioners don't have any ruling on process. The process was we would like it to be re-notified because we were notified. Steve wasn't notified, and no one's ever seen that letter before. We had a weekend to prepare a submission. I emailed. We're part of a block of Māori farmers. Me and Matua Bill emailed out to the Māori farmers, about 5,000 hectares in that network through the mid-north. They didn't get that email until the closing day. One of them that did, they didn't have time to respond. They're deeply impacted on this, their subdivision. So yeah, it's unwrong. When you look at those 33 kVR lines, there's not a lot of owners. It's not a hard process. I got a notice yesterday from the regional council, shows a map, explains exactly what's happening, how I'm affected. What's wrong with that? That's for the whole Pururu Peninsula.
we're not saying what's happened is correct or incorrect. We're just saying we've got to deal with what's before us.
Yeah.
Understand.
Well, so on that, some of us were notified. A lot of owners aren't notified. Otherwise, they would be here today. There was a proper process, and so we would ask that to be re-notified, and any decision to include it should be delayed until a proper notification process has been run. Order.
Yeah, let's get on to me again. So yeah, already covered a lot of the points in there, but the one I really want to get on to is the third point there, which is the definition of a utility easement. And how I see it, if this goes ahead, Top Energy has requested, and the council appears that they might be putting in a utility easement across our properties. And I've looked at the sort of the definitions of easements, and that's what we've come up with utility easement on the websites, which is from what lawyers have actually. And yeah, in effect, there's rules in place, and we've abided by them. Top Energy and the power companies have used them. And those rules have basically been sort of sitting there. And what's getting proposed is now the mapping of our lines, here on our property. And also, there's further restrictions being put on beyond the provisions in place, which is the Electricity Act, safe distance, and all the rest of it. And so that is actually an easement. And if you look at the flow of what's actually happened, which I was going to cover on my last lot, but I'll do it now. Those lines, when we went there on our own property, were there 45 years ago. There was legislation in place, presumably, to protect them and the usage of them. And then the electricity lines, as well as the infrastructure around the country, then got put into private ownership. And then there was legislation put in place, in particular, the Electricity Act of 1992. It also says in the Electricity Act of 1992, on the 1st of January 1993, any new lines or upgrades or whatever are to be mapped and put onto people's easement property titles, which is classified as an easement in grace. So we're now in 2025, and what will be going on is that it's going to be mapped. It's going to have a clear definition across our properties. And on top of that as well, there's going to be more provisions put in place which exceed all the current legislation. Now, if that was to be put onto a title deed, it will be called an instrument. And it will be clearly mapped. So that, in effect, is a utility easement. And I believe that this could actually end up being some major legal arguments involved in this. It appears to me. It hasn't been tested yet, but as Mario has stated, there's been poor notification. Since we've formed our group, we've notified a lot of other people. They can't participate in this because they haven't submitted for obvious reasons, which Mario pointed out. When they find out the implications, and also the people don't actually realise, there's a strong possibility that we could possibly get together as a group and actually dispute this thing legally. So I think my recommendation to the commissioners, for what it's worth, is that we just leave the way it is, the status quo, and then identify the 110 kVA line, which I think are relative to the whole thing, and map them, but just leave the 33s alone. So, yeah.
What would be the problem of mapping the 33 kV lines anyway, without any provisions in the district plan relating to them, but they're just mapped so people will know where they are?
Is it necessary?
Well, it's an information base.
Well,
if anybody's looking.
How long have we gone on without having the map and actually got through? If you look at my original slide, my slides back there, and then the electricity problems which top energy is identified, hardly any of any of those are actually related to 33 kV lines. So what's the reasoning behind it? And I'll tell you why. We object to them being mapped, because once you got it on a map and you get into what I call, which we're doing at the moment, a war of words, and you get interpretations and they change. That's why we've had to employ somebody professionally. Next thing, that's going to be extended. And as far as I'm concerned, if Top Energy want to upgrade, in my opinion, it is, if Top Energy want to upgrade, they're going to go to Mario as an individual. They're going to go to me as an individual. So if they go to me as an individual, I'm going to ask Bill and Mario and the people behind me to help fight them. They're not going to want anything to do with it, because I'll tell you what actually happens. Their stock answer is this: take us to court. It's going to cost you $250,000. So they're just going to pick us off. So once that's in place, they can keep on stepping it out with justification. That's how we view it.
Okay.
So to me, that's why I don't believe the council did not want to map them in the first place, because they could see it. Because if you go back to the RMA section 2, like if you go back to when I read of it, it's a document, and then it's being reinterpreted. And next thing, we're sitting here, and then the regional policy statement, it's a suggestion. It's not actually a rule. It's no clear directive. It's just interpretations. That's all it is.
Okay. All right. Have you got a question?
Yeah. You said earlier 2 lines run through your property. Is that your combined
Yes.
property or yours personally?
There's 3 of us that run through.
Do they currently have easements?
No, they don't, Steve. Nobody in this collective has got a registered easement against their title.
So it goes back to the you've referred to it a couple of times, the Electricity Act 1992, which allows the power company, subject to your entry approval, that they've got the right of entry to maintain, operate, upgrade anyway.
No issue with that.
So what's the problem?
Don't know. That's where I'm getting to with it.
Exactly, Steve. What's the problem?
So that's my next question. So what are the you said there's no justification to include the 33 kV as regionally significant, but what are the particular issues that you're worried about? Your land use restrictions?
So the next slide will.
Oh, carry on. Sorry. Carry on. Yep.
So Excellent. So I don't know if you can see that in the left-hand column there, we've got, now they're currently under the Electricity Act 1992, they're able to access the property, as you say, Steve, and do all those, do what was required to maintain the lines. What they're seeking for in this process is much more. They're seeking further setbacks. They're restricting, and then outside that setback, they want to put restrictions on what we can do. So not even in the setback. So if we've got a 32-metre setback for a subdivision, even then you can't have the black building on straight on next to them. You know, so that's how we read it. And so they want to, as we read it as well, they want to have rights over environmental, cultural and health standards, go through those things as well. So it's an impact on us because also the trees underneath it, we're going to be then forced to keep those trees away from their lines, like even if it's the bush. If you've got areas that can't be used for anything, or they can't be used for farming, which would typically be planted in trees, we now have to manage it. We'll be responsible for cutting those lines, trees down if they get close to the lines, even though there might be just second regeneration bush, because we've retired that land. So the loss to us in terms of private property rights, in terms of land restrictions on what we can do. Some of us, you know, we've got we've got titles on this property. It's going to run right through all those titles. And so then further reducing the opportunity to establish a building platform. But yeah, lots of income, limitations on future development. And just, compliance cost to us. So it's unnecessary. The current Electricity Act, as you point out, Steve, is suffice. They don't need anything more than what's already there. And there's no justification, as been pointed out by our planner, and reiterated, there's no justification for their inclusion, particularly on our properties as well. Next slide. Oh, yeah. So again, I heard the Commissioner's comment about not interested in the process of council is run, here to make any decisions on that. But there's another, that is partly why we're here, because it is unfair. There's a lack of natural justice here. Affected owners, if the people had proper notification, sir, they would be here. I can assure you, we wouldn't be in this room. The fact is that it was a poor notification process. It was delayed a year later. People are overwhelmed, and even if they did get it, and so the affected owners aren't aware. Here's an example. Just that picture up there is from Waima Tōpūpi. Sorry, you've got that there.
Oh, sorry.
They were unaware. And I emailed her on the Friday after finding out on the Thursday. She had till Monday to do the submission, and they didn't get there because she had a board to talk to about it. Māori entities have a whole lot of other things, dynamics as well to deal with. We've got boards, we've got shareholders, and we have to talk to them as well. So yet they're heavily impacted by this development.
Just clarify something, Mario. So it was a further submission they had to utilise on the top energy submission.
Yeah,
There's no original submission.
We understand that. Yeah. We understand that, and that's
That's when we got wind of it. But so yeah, a lot of Māori land is affected. They're a Māori entity. Like Bills, we're a Māori entity. But even the private owner, we've got Steve here. He just wanted to talk about how he's affected.
I think there's a letter. Is a letter from Steve attached to one of the evidence? I think.
Yeah. Yeah. But he's just going to talk to a couple of slides.
That's all right. Yeah.
I kind of read out there might be a few mistakes, but it's, what do you think?
Oh, you have made mistakes as well, have you?
I just think it's oil spot.
We're labouring. We're not paid to get it right.
Well, I see this letter here has got a mistake and it's got 100 kV instead of 110.
So, tēnā koutou, Kaitāia, commissioners, council representatives, planners, and the members of the public. My name is Stephen Boys. I'm standing here with the Aotearoa Landowners Group to present my lay evidence. I was one of many of an area who was not able to submit an individual submission, as I did not receive any formal notification. We purchased our property knowing that these lines were situated there, but now things with the changes that Top Energy are proposing, it will have an impact on why we bought them in the first instance. We bought the property to allow our children, our grandchildren, the opportunity to have somewhere they could call theirs. Kaitāia type style, because we're all aware of how increasingly difficult it is to own your home in this country. Patricia and I have fenced off the waterway, started replanting the headwaters of Waikini River for the betterment of our property and the wider picture. We enjoy what our property has to offer. We want to offer our future generations to come enjoy what we are creating. As you can see by the slide, the contour of our property limits the availability of potential sites where houses could be and can be erected. Top Energy's proposal will further restrict availability of housing. What Top Energy is proposing, it will reduce our land's capability by increasing the restrictions. I estimate, this is just my estimate, that our potential restrictions could be up to 3.588 hectares from a total of 16.2.
It helps not to get scared.
Yeah. In my view, Top Energy proposal plan has a potential impact on Patricia, myself, our family, who will be seriously affected by the changes. Top Energy has not communicated effectively and begs the question as to why Top Energy has not taken the opportunity to send out individual letters to property owners. Also, I believe the council representatives have let the ratepayers down to be misinformed due to only having one type of communication from a company trust who, by their own admission, is intending to gain further control with imposing further restrictions on landowners who have the 33 kVA lines running through their property. This proposed plan will have an undesired effect on many properties throughout the district. Other property owners who will have plans for subdivision or planting on said properties that will be affected if Top Energy can change the status of the 33 kVA lines. This will have a serious impact of livelihoods of future growth of our district. We've also become aware as it stands there is no easement on my title. There's been no communication from Top Energy to me or Patricia to discuss how or would Top Energy come to an arrangement for the lack of easement. In conclusion, I implore the Commissioner, the Council, to reconsider the proposal from Top Energy as the impacts will be seriously detrimental to our property and our futures. Amen.
Thank you. And I just have a good question for you.
Yeah.
This illustrates obviously what could happen.
Yes.
As my colleague just asked before, I mean, when we deal with this, we hear from everybody and then we make a decision, and sometimes one side wins, sometimes the other side wins, sometimes both might get something. In this case, if we did decide that we would still map the lines, but leave it for the provisions under the Electricity Act would apply, that wouldn't. You've got no further restriction apart from that. People know that if I want to go and buy your property,
Yes.
I'll see on a line, oh God, it's got a 33k line through there. I don't want to be anywhere near a power line. It's more of a warning to possibly future purchasers. But if having the line on a map and leaving it to the Electricity Act is not going to change anything that you've got now.
No, it's the possibility of the future restrictions by the extending the setback and what you can actually do underneath.
What are you saying?
If we just leave it what it is now,
Yes.
and apart from putting a line on the map,
Yes.
there might be a win-win for
Yes.
both parties.
That's why I'm planning
Yeah.
interested.
But anyway, yeah.
Yeah. Yeah. As I said, we were aware that lines are there in the first place.
Yeah, I know that.
Can
Yeah.
I make a comment on that?
Well, yeah, I'll get Mr. McPhee first because he's the expert from your.
Thank you.
No, I was just going to mention if it's identified as a critical electricity line, then the line would matter because there are rules in the postage plan on a critical.
So what happened if we just identified it as a 33 kV line?
And not a critical electricity line?
Well, that's, I mean, I'm just.
Yeah, well, if it's not included in that definition, then the line is just a line.
Okay, okay.
Yeah, the comment is going to make, if you go and buy a property, surely you can actually physically look at it.
Oh, yeah, I understand that. Yeah, yeah,
And
yeah,
then
yeah.
you see the line.
Yeah,
And then if you've got an objection to possibly the radiation coming from the line, which we have got an objection to, because we're worried about them upgrading them, you wouldn't buy it. Yeah. And then if you look at Stephen's map, I don't think he's properly sort of described it to you. If you look from the southern side, where it exits the property, which is future building site, if it's got set, that's the only place that you can build on that property.
But he's going to have restrictions now under the Electricity Act building there.
He can probably still get in that spot where he wants to go.
Yeah, I'm not arguing. So if we didn't say it was a critical electricity line and those other new restrictions apply and left it just that it's a map, the line 33K is identified on the map.
Yeah.
He's going to still have the same development rights in the Electricity Act as what he's got now.
That's right.
It's only if we say it's a critical electricity line and all these new things apply that it's going to change. But by identifying just the line on the map and not referring to a critical
That's
electricity.
also another old saying too. Give an inch and take a mile.
I understand. That's why I'm asking the question. That's why I'm asking it. I mean, we may not decide to do that, but I'm just asking the question.
There's another saying about sometimes it's better to accept the compromise and stick your head in the sand.
Yes, I agree with you.
When you do that, what's sticking up?
I hadn't thought of that.
Yes, I've actually noticed. Yeah, I've noticed that. I've noticed that Pop Energy's submission, original ideas have been popular. That it's just pleasing.
Yeah, you were saying before about people looking at potential purchase of a property and they can go out and have a look at the property. But I put it to you that if you went out onto your site, you wouldn't see an easement, you wouldn't see a number of things that are quite relevant. So you'd search the title or you'd look at the district plan, because at the end of the day, the district plan's an information base. You might find there's a paper road on your land. So you look at those various things. So the fact that it's mapped and it just relies on what's in the Electricity Act is Bill saying there's no more than what's the current situation at the moment.
Yeah, well, I don't believe it is necessary to be met, because any decent solicitor will actually point it out to the restrictions which are actually in place.
Decent solicitor being the key words.
Yeah. Well, they charge enough, trust me.
All right, okay, carry on.
Do diligence and you find that first thing is you look at the titles, there's no registration for the titles.
Yeah.
Then you won't have consents.
Okay.
But anyway.
Steve's got a question.
Oh, no, sorry. Carry on. He might answer it.
Oh, okay.
Ask it quickly, Steve, but I may not.
Now, well, from, I think there's 2 points. One is the process issues. I'll have to talk to my colleagues here. I'm not sure that we can do much about it from my commissioner seat, but with my councillor hat on, I will be bringing it up in a different forum. The questions I had, you referred to, and basically from my point of view, you're talking about property rights. And in your, Mario, you had a slide a couple back that you referred to the different items where the losses would occur, which is higher compliance, loss of income, limitation on future development, which was pointed out by Mr. Boys as well. What I'm asking, probably need Mr. McPhee to answer, is if you look at what higher order, whether it's the Act or different provisions, would gazump this mapping? Are there any? Or does this take precedence over everything?
Not sure what you mean. So we've got
Well, under the Electricity Act.
Yep.
Yeah, they've got all the rights in the world now.
Access, yep.
Yeah. So what if this mapping goes ahead as it is under CL? Is there any other? Does the Electricity Act override it? Is there a higher order, whether it's a regional policy statement or anything else?
If that's your lawyer, then it's a councillor.
Yeah.
Now, well, this to me, from a commissioner's seat, this might actually give us a steer on where we go with it. That's why I'm asking. And it might be that we go back to our reporting planners and say we need advice.
Yeah, I suggest you do that because I'm not intimate with the NZECP 34/2001. I mean, the RMA's got like a requirement of 75(3) to give effect to regional policy statements and national direction. I don't believe that's in the national regulation, but it would seem strange you've got national direction and then at the district level you would impose something more onerous.
You're under Mr. Simpson's, he referred to no justification to include the 33 kVA and regional significance. Indicated Top Energy's given misleading evidence, process issues around notification. There's a whole lot of things there that you're highlighting, and it's just like, well, what's the long-term impact of mapping this? And then if you're correct with your definition of utility easement under the CL process, critical electricity lines, that does become something that I'm sure there'll be more than just your group will challenge legally. So that's from my sitting here as a commissioner and looking at the bigger picture. That's what I want to know. Is there something above that? And my colleagues here can probably tell me that. But I just asked the question anyway, and I get growled at lunchtime.
Well, I read the Electricity Act.
So
Unfortunately.
Yeah.
And I can't see anything in there about mapping. Well, I read it. Yeah. And the other thing I want to get onto too, Steve, I read the RMA, unfortunately, section 2, and I just make a statement here. We're not Whangarei in the Far North District Council, otherwise we wouldn't be having hearing meetings here now. What it says in the RMA is that if something's in one policy, or the majority of policies, district councils, RMAs around the country, regional policy statements, it has to be followed and adhered to as a nationwide thing. Well, I do not know, other than Whangarei, the only one is the only outfit that I know which is actually mapped. Yeah, I do not know. Yeah, I don't know. And what I'm saying, are we going down the right track because of Whangarei? And I say no.
Maybe we should look at what they're doing in Auckland.
Exactly.
That's a facetious
I've
comment.
asked lawyers and I've questioned people over the period of time I've had, and if there's anything, it's like a secret society. It's hard to get a straight answer unless you open up your checkbook.
Okay, if you want to carry on.
Okay, I agree. Yeah. So this is a costly process, and it's an unfair process. And that's to say, for notification, we got together. We wouldn't be here. It's unlikely we'd be here as individuals. Our neighbours, we've banded together. We've had opinions. We've gone to a couple of lawyers. We've had opinions. They say there are legal arguments that are sitting in amongst all this. But the cost for that, so just the cost to date, we've spent tens of thousands of dollars on this. And shared amongst the 6 of us, it's not so hard. But to get the KC, to get her here with her team today was going to be a lot of money. And we decided to delay any legal arguments because this is a planning process. We accept that. I think the point we're pointing out is this is for the region. There's no consideration when I go through and read the section 32 and all those reports. There is not, I can't find anything that talks about the affected landowners and in consideration of those landowners. So it's a gross process. You have industry that come in with all their lawyers and planners and everybody's sitting around having a food fest. Meanwhile, the affected owners are expected to try and navigate through this process, go and stop what they're doing, their daily lives, and go and try and keep up with what people are trying to do to their properties. So it's to the point that those things out there. And just on the picture slide here, again, is one of our members who couldn't be here. He's welcoming a new grandchild in Auckland, but he has got 2 lines you can see there, and he stands to lose a lot of money too with a further setback on his property. He's got forestry on there as well as a house site that's going to get lost. So it is a costly process, and it's, I guess that's the point. Well, we're talking to the council at the table, I guess, to have consideration in these processes of the owners, because the commissioners have said that they're just looking at this.
Yeah, what you're suggesting is the losses compound over a lot of properties. I get it.
I mean, like, I think Daryl is, essentially all these hundreds of thousands of dollars from potential of this, the proposed setback.
Yeah, I know it's property. Yeah.
Yeah, so it's like.
So, yeah, so just in conclusion, for our group, we're just saying that we believe that the Electricity Act is suffice. If there is an insistence on including the lines as an overlay, as a cell overlay, then it should be properly notified, and people should have the opportunity to come and have their say. Otherwise, yeah, the status quo should just remain.
Is Gary's here as well, is he?
Oh, yes.
Yeah, so we actually received, we didn't think you were appearing, but I've read your submission as well.
Yeah.
Outlines what you've,
Yeah, that's fine, Murray. Yeah, no, I because I knew that I was, I didn't ask to be heard, because I knew I was in this group.
Yeah.
Yeah.
So Mario, the other slides, are you going to go through them?
Yes.
Oh, okay.
Yeah, so that, I guess that concludes us as a group.
Right.
Some of us wanted to speak to our individual submissions
okay.
as well, because we're delving into more personal stuff.
Yep.
As I say, we're a collective. We try and come together. They would, Aaron sort of stops the tractor while he's putting food on, and we, that kind of stuff. So we probably just wanted to speak to those more.
Yeah, that's right. Yeah, I just didn't. I thought you would missed it out. That was all.
Yeah, no, that's right. That slide's ordered that way.
All right. Okay.
So we back to order my way.
carry on.
Listening to us. So, respective personal steps. Okay. You've got it up in front of you. I sat down and I've actually written something a little bit different with respect to the one I've got up on the slide. And for me, as a representative of our hapu, I'm attempting today perhaps to promote more holistic and emotional and spiritual impact on us as people. So I related this morning where we're situated, the tribal tribes, etc. So, as I said, my name is William Pane. I'm a servant and a kaitiaki of our collective whenua in Omawe and Ota. So, tēnā koutou morena te paura whenua ki te whakatūranga o te taupapa tū nei a ke te awa. So, greetings to you, commissioners, on this morning. I'd just like to go to of our 6 hapu named, 4 rangatira signed the whakaputanga in 1875 and the Tiriti in 1840. For example, Whanati Rahiri was Maripō, Te Ngare Haueta was Haki Taipa and Maripō, for Te Matarahi Rahu, it was Whanahiki Tōkai, who was first to sign the Tiriti and latterly attributed to chopping the Flagstaff down in 1844. His descendants, who knows, I can't control them, they'd be chopping down some power lines, power plants. And then the last one was Tāreha Kaiteke Emera. He was a famous Tuhunga priest and a rangatira from Hakaraka or Omawe in Waiting.
As senior chief and talking of the locality, he was assigned first night at the Hui on the 5th of February to open the speeches. The mission printer, William Colenso, recorded the Cameron speech, of which I quote extracts. So health to thee, O Governor. This is mine to thee, O Governor. I am not pleased towards thee. I do not wish for thee, Governor. So that's how I feel this morning as far as I'm referring to you as Governor. Well, not so much you, so I mean, say, the council in this case, but, you know, the Canberra will be judged and condemned. Yes, indeed, and more than that, even hung by the neck. No, no, I shall never say yes. We're all to be on an equality. And those are some of the things I'd like to point out, and I'm sure many of us, not only Māori, have asked for those similar things over these many, many years. Then perhaps Te Kēmara would say yes. So perhaps Wiremu, on behalf of the Trust, would say yes, as we've tried to point out this morning, if it was a process was offered to us as one would expect, and consultation, collaboration happen. The Kēmara would say yes, but for the governor to be up and the Kēmara down, governor high up, and the Kēmara down, low, small, like a worm, a crawler. That's exactly how I feel, and I reported this to our board and the beneficial owners that I see from time to time, and that again is how we feel. In being not only in this instance, but it seems to be something that happens quite often. So, no, no, O Governor, this is mine to thee. O Governor, my land is gone, gone, all gone. So I could point it out this morning, the land that has been, can I use the word taken, for the power lines to go through our property, we actually didn't have control over them at that time. We were in limbo. The lands were ours prior to that, and then by legislation, not paying our rates, being in a status of undevelopment and so on, they were slowly taken from us. So it's all gone, gone, gone. And then we've had the opportunity of going through a process where we're able, and the opportunity arrived, to purchase this back at market rates, and we did so. He goes on to say the inheritances of my ancestors, fathers, relatives, and gone. So he's saying, return me my lands, return to that man to hammer his land. Let us all be alike in rank, in power. Then, O Governor, remain, but governor up, the Kēmara down, low, flat, no, no, no. So I wish to, on behalf of our hapu, ask for consideration that we go through this courteous approach, allow us to engage not only with dignity, but give us opportunity to have our say at least. And that is not how we feel that we've been treated today. In terms of, as you can see, if we could get the letter that you have identified, no, we haven't. Simple things like that, but they're not simple. So we firmly believe that the FNDC PDP process being conducted in conjunction with Top Energy about firstly the proposed upgrade to electricity lines travelling over our lands, notwithstanding the price taken in originating and implementing the current lines is akin and echoes the sentiments of our ancestor Kaitāia. So what I ask, and how does, as I say, they all signed the treaty for them. Does the treaty or the treaty covenant reflect the best practice standards of consultation and collaboration, operate between central and local government agencies and their partners with Māori? And I refer to, of course, the Resource Management Act. Was or is consideration being given to enact this agreement at some stage? If so, when? Annually, as an Ahawhenua Trust, we distribute to our beneficial owners and beneficiaries 30K, and this has been for a long time, as grants. Grants in the main education and a portion of that for the aged. To challenge and object to the PDB process undertaken to date with uncertainty of what the future may hold. The trustees are devastated that the prudent results of our business endeavours, and when I talk about our business endeavours, we just talked about it on Monday in a strategic planning meeting that we were there to refresh. And we just talked about our business endeavours, and first in facilitating, we said, where does your farm fit into the thing? And from all the expert advice from consultants, etc., that visit us from time to time, they are saying we would be one of the top 10 beef and cattle, beef, sheep, and cattle farms in Kaitāia. And like I said, these are the prudent results of our hard work. We're not paid as trustees to be there. Most of us are there voluntary. So the $10,000 that we have currently spent to date, that could have gone to 2 education grants and a couple of kaumātua grants. You know, that's how we look at it. But we've had to find money outside of our annual budget to come here today and express our feelings. Not only that, I feel we've also been subjected to further costs asking to travel to Kaitāia, which is a long distance. So, like I said, yes, the trust will afford me, compensate me for travel arrangements, but not for my time.
Just to explain, we've had 3 days of hearings here, and we had this Monday at the Roma Marae, so that's why we're up here.
Yes.
And because it's a district plan for the whole district, with the council and the commissioners want to get out to the area, and it's just unfortunate that you've down there and we're up here. That's unfortunate. It's very unfortunate.
Like the Kim would have said, you up, we down. So, with all due respect, let me say like that. Again, we religiously pay our land rates to council, 40 grand a year, who in this instance mount a process utilising ratepayers' monies, ratepayer funds against ratepayers. So here we are, we paid our rates, and then the council introduces this process. We have to raise further funds to respond to what we believe is outrageous, unseemly and immoral, to say the least. And what of our diminished lands that remain in our hands under the Māori freehold title versus general title? Of course, we're administered by the Ture Whenua Act 1993. Here's another legal process to be pursued in terms of consultation and collaboration. So as I understand it, for example, Transpower, if they want to make any changes within our lands, have got to put an application, file an application with the Māori Land Court. Not us in the first instance, but with the Māori Land Court. So it's all of those things to go into. I know these are only proposed changes, but certainly they do have an impact on us. The reclassification would impose additional restrictions on how we manage our tenure, This could limit our ability to develop the land in alignment with our long-term strategic goals, which includes sustainable farming, environmental restoration, and future economic opportunities for our shareholders. So at the moment, I can perhaps raise an example. In the last 6 months, we have undertaken a water feasibility study. We've almost completed that. And now we're looking at a forestry feasibility study. So, we do have future plans, as one should have, around our lands, especially when we've got all our eggs in one basket at this time. Certainly we've been looking at the study of water is actually going to give us options, perhaps in the way of horticulture and gardening. And then, like I said, we have also been looking at for a number of years, and I'm going back now 30 years, it's been on our trustees' agenda at Kaitāia, those kinds of things. Tree planting, we say Demetrius, and all of those impact on us as well. So we do have 3 blocks of forestry in total 24.5 hectares. The farm itself is 1,000 hectares with 700 odd that is effective. Then we think about being a Māori farming on our papa tipu whenua, where our ancestors grew up and roamed. They also live on many areas within the block. So we have some sacred areas there. We consider the sacred areas to also be the ancient hainga or homes where our ancestors resided. And basically, I guess it's a loss of control over our land. I'm going to end with a whakatauki, a Māori proverb. It says, "Whatu ngaro te tangata toitu te," which basically means, as people disappear, the land remains. And I'm here after many generations of our whānau being present on the land. It emphasises the enduring nature of the land in its importance, whilst acknowledging the transient nature of man. We are ahika, so we keep the home fires burning. We are tangata whenua and kaitiaki of our inherited Ōrāmahue public whenua lands. As our ancestors who attended the First and Second World Wars attested to, on behalf of our whānau hapu, and especially our tamariki and Nōhupuna, ka whawhai tonu mātou, ake, ake, ake tonu atu. We will resist to the end. On behalf of our hapu, thank you for the opportunity to present and listen to me today. Ngā mihi, mauri ora kia koutou. Thank you.
Any questions? I've only got one question. You mentioned that you've spent some money so far within this process.
Yes.
Say, for instance, we decided, right, we're going to stop the process and because we're not happy about something, and I'm just talking out loud at the moment, and then the council decides to pursue it with another option and notify everybody or Top Energy, you're then going to have to probably spend more money. So if we dealt with it today or during this process, would that not be better for everybody if, depending on what the outcome is, as I was talking earlier, possibly putting the lines on the maps and then not identifying as critical energy, just identified as a 33 kV line that's there, leaving it to the Electricity Act to deal with. And then if either the council or Top Energy in future wish to pursue it, then they would have to go back to all the owners and notify them. They may not decide to do that. They might just leave it as it is. Which outcome would you prefer if we?
I believe, given the the nature of the issue, we call it an issue.
Yeah.
Or the matter, and being promoted as national significance, I would not expect it to end with the community. I would think it would be put in the interim basket to be taken up after perhaps council, whatever the decision is, whether it's is to stop or to continue. Stop, I would believe, would be an interim thing. They would regroup, look at the information they have, and perhaps say, okay, what did we do wrong and how can we go forward, and then take into consideration the ratepayers' concerns. So, one, the money that we've spent today, I would not expect, perhaps, if it's not too far in the future, to be employing a planner again. We've got that information. Perhaps there's some legal aspects that we might have to look at in the future. So that's another story, and we'll cross that bridge when we come to it.
Okay.
If perhaps the commissioners are successful, hypothetically, in saying to council that it's to stop here today. Not too sure what timelines we to stop it, because it's something we'll always start up again. New people come to council, etc., etc. But it could reasonably give me good consideration to perhaps make a claim against council for compensation of the monies that were spent today. I don't know.
Okay.
That answers your question.
Yeah, thank you.
Yeah, kia ora mātou. You brought up the process issue again, which I explained earlier, and I'm also a little concerned that we may have offended you in some way by our process, not proper protocol, other than James Karakia. So apologies for that. No intent there. But you've pointed out, you know, the presentation, consultation, collaboration, and should have followed Te Tiriti protocol with respect to consultation with Maori. And so there's a few things there. You also mentioned Te Puna Kokiri approval for Transpower, for instance, if they do anything with the lines. Does that apply to Top Energy as well? Or have I misunderstood that?
It's not so much TPK, it's actually
Maryland.
Te
Whenua, sorry. Okay, so then I'll get back to the property. I know the land pretty well.
So just to be clear, does that apply to Top Energy as well? Because I think you said Transpower, but if Top Energy wanted to...
I would think that, like we've tried to present today,
No.
the guidelines come from Transpower, whatever.
I think he's under the Public Works Act, they're required to apply to the Māori language.
So
that's with the National Grid.
Okay, thank you.
You know, so these 33 kilowatt lines, which
aren't part of the
they're
national
trying to
grid.
include, well, there's no defined process like that.
Yeah, that's why I asked, do they require the same, do they notify via the Maryland court? So,
Well, like I said, I'm only a layman, and I've done the research, Google this and that, and it's been really difficult to actually get information online as to what applies in terms of legal requirements for persons such as Transpower to come onto Māori freehold land, because we're not general title land, we are Māori freehold land, and we're administered by another law, which is the Tule Whenua Act, and in that circumstance, it says that an application on anything like this should be sought from the Maori land. That's what I understand.
thank you. Now I'll refer specifically to the whenua. There's a couple of things. Where the power lines run, I mean, I know the property reasonably well.
Yeah.
It is highly productive. How much of that highly productive land you're looking at alternate uses? So how much of the highly productive land would be affected by the setback?
Thank you, Mr. McVeigh. So at the moment, like I said, we've been primarily beef and sheep farming. And where the lines come through, from Markwood Road to State Highway 10 is probably one would consider to be some of the most productive land we have. So, like I said, we've been doing a water feasibility study to look at an option of horticulture. And we have also done in background an environmental, we've got an environment, et cetera. Interestingly, we have 7 different soil types, and the richest ones for gardening and horticulture are where the lines come through.
I thought that might be the case. And in addition to that, I mean, the council have invested in the dam up on Te Ahuahu Road for exactly this purpose, you know, change the land use. The other thing you referred to your sites of significance, so whether it's Waitapu, but there's another part 2 of this plan refers to district-wide matters that may be relevant for this particular chapter, including heritage area overlays, historic heritage sites and areas of significance to Maori, ecosystems and indigenous biodiversity, natural character, natural features, landscapes, coastal environment. So this is part of a bigger picture. So those sort of issues you mentioned on behalf of the iwi or Hapirapu you're representing here, they are also, there's another part to the plan that we have to look after. So it's just another part of the juggling match for the commissioners here.
So like as perhaps like I said, perhaps if I can say with humility, I'm the senior elder of our tribe. This is not the only Māori trust that I've been involved with. So I was involved at Waitangi and TV3 I was basically a trustee and a chair there for 20 years. I've just retired. And so I've come to meet a lot of council members. Unfortunately, I don't think I've ever come across you as yet, but I've been asked by council, even today, to take to assist by taking an active role in some of the matters that come before the council from time to time. And the current one at the moment is the Harudu Waitangi Kaitāia Upua water supply. So I've been asked to go on that panel to assist in the thing. Now, all I'm asking for consideration is that's been well notified. It's it's a great process. This appears to be all topsy-turvy to me. I would have expected the council, such a serious matter as we're charged with today, to follow that similar proper process.
Yeah.
And unfortunately, I don't believe that they can. Thank you.
Thank you.
Thank you very much. No, thanks very much for your presentation. Thank you.
Smith. Ko tukerau te maanga ko te karai maanga nui te awa. Ko te tite kāinga ko hiru harama hau ko whiti ora ngā marae. Ko Ngāti Rehia te hapu. Tēnā tātou katoa. Tautoko ngā kōrero ki te kai whakariti te atanei ara te kōrero a tuku matua. Kōrero a tiki a koutou I mua. Just reiterating, just endorsing the acknowledgements Matua Bill made and also the opening today. I'm sorry that I was at hearing 10.
Pardon?
I was at hearing 10.
Okay.
At the centre, and so up here again. And the screen was much bigger.
No, I'm
So
sorry.
when we were doing the PowerPoint presentation, I thought of that big screen, so I thought it would be really.
What we'll do, we'll copy this during the break, and each of the commissioners will have a copy
Yeah,
of this.
so I'm sorry because the presentation was with that big screen in mind, not this.
Would it help if the blinds were moved down so you could see it or not?
Oh no, I've got a copy.
Oh,
here,
okay. Oh, right.
So I can read it. It's more the commissioners.
That's fine, Mario. We're here to listen.
Yeah.
Carry on.
But That's home. That is home to thousands of descendants of Kaitāia, and that's Te Tii. And our whānau have been on a journey for quite some time, since 1964, trying to hold on to that and our adjacent lands, which is Tapotahi. The raiding scheme was aggressive in the 60s, looking to come and take the land. You heard Matua Bill talk about that. And so our people got together and they formed an incorporation to try and start a farm to pay the rates. Just like my grandmother's people in Matoti Bay with the camping ground, which is just there to pay the rates. We have fought to hold on to that, and our rates at Tapotahi, without the farming concession, would be 60% of the gross income as a farming operation. It's only 120 effective. 200 hectares is a native bush, and that's just simply because it's whenua Māori, so it's never had access to capital because the land has never been able to be used for security, and so it's never been developed. And now we've got a whole lot of rules coming over that as well, but that's another hearing coming up. But so we've been on a journey to get, the farm has never been economical. Even with the rates concession, we're still paying on average about fourth in rates for our land, which is higher than tax we pay, but we don't make any income off that solely. And so we've been on a search to try and get economic scale, which has led us to the Ora property. But just before we leave this slide, I'll just make a point that we have $500,000 with the postponed rates on there as well. So we're trapped in farming, and to a degree, unless we want to pay that money to get out of it. And then we would have to be paying those exorbitant rates of, because we'd lose that farming commission.
So you're rated on a special land value basis, based on farming value.
Yeah, which is an old thing. You can't get it anymore. I think there's only like a dozen or so that have got it in the north.
Yeah, that's correct.
But yeah, the rates would be, so the postpone rates come in about 55. You know, you might make $100,000 off that if you're lucky as a beef unit. But Tapotahi itself is, we've got 1.8 FTEs. I'm a 0.8 and our farm manager's full time. We have 5 volunteers, just like what you heard from Matua Bill. We too have 5 volunteers that sit on the board and govern the organisation. And yeah, leasing and farming. Leasing is probably why we're still there. If it hadn't been for our lease business, which I understand Commissioner McNally is very familiar with, and give you a breakdown over lunch on that. But yes, since 1965, we didn't see any return of the leasing business that could go significant benefits back to our people as well until 2008. So there's been a long time to try and get something back to our people other than pay the rates. So on our journey to get what we call economic scale in farming for 1 FTE, that's led us to Te Whānau, when we bought initially a 198 hectare block. It was incredibly run down, and the price reflected that, and that's where we had the opportunity. The land values on Purerua are just, even in Waipapa, just too much. We couldn't afford, we will never recover that through farming. And then in 2021, when we looked at this property in Te Whānau, we had a brief that we were looking for. It took us a long time, took us years to find this property. One of the things that really stood out to us was all the individual titles on the property. There's 20 titles. When we did our due diligence and we saw the power lines, there was nothing registered against the power line, no easements, no nothing on the titles. And so yeah, we've bought that block to become our Wagyu Angus breeding farm, of which we supply to First Light Foods. It also has some property on it, some forestry on it as well, which again is will be affected by the further setbacks if they were to proceed, as we understand. And then in 2021, the neighbouring property came up for sale, and we moved to buy that one as well, which is another 76 hectares. And so that's called and we've called that what's a bill named it Kaitāia for us. Right. So the issue and concerns that we have over what Top Energy is proposing in their submission to the FNDC, and we're asking the councillors to think of is well, we made the point about previously about no notification. We weren't notified at all. We've got no record of notification, and you get five, 6 rating notices. So, and we get 2 for these farms. So, I'm surprised if they've got our address. But the setbacks will definitely retire those areas in those setbacks, and even some of the lands adjacent to that to farming, and not along with some of the plans that we have. We're currently doing a 5-year strategic plan, and we've got a subdivision at Kaitāia where we're learning about subdivision, and we've looked at, there could be a development here in Farmer when we do the planning there with all those individual titles. But yeah, and I think the big impact for us is on those individual titles. If subdivision rules allow us to proceed, if documents are not reflected. The other concern we have is that those 33 kilowatt, those definition of upgrades and all the different words around that. I think Simpson might talk a little bit about that later, I'm not sure. But if those lines are upgraded to 110 kilowatt, the impact that will have on the subdivision and the health benefits. And Steve's at the top of our property, so his house would definitely, no doubt, feel something from those 100, if they were 110 kilowatts, because you're not far from the lines, are you, Steve? And then, of course, the other thing is that if this is addressed, this was an investment property. The loss of income. We've invested a lot of money in these properties, tidying them up. Very, very tidy, new yards, fencing, waterway fencing. Just finished 32 kilometres of fencing on one of the properties. So, and that's half of that is perimeter fencing. So yeah, so Taputa is asking, again, similar journey to Matua Bill's kōrero around Urumahoi Farm Trust. We're asking commissioners to consider the impact on us in sort of our journey, and also as a Māori entity. As a Māori entity, we also, I wanted to point out, and Steve alluded to this, we have to navigate through Te Ture Whenua Māori as well, and also the Māori Incorporations Regulations 1994. So we also have to navigate through those over and above all this other legislation that we're dealing with. And so I don't know if any analysis has been done on the Te Ture Whenua Māori and how a proposal in the district plan might impact on it. And then on top of that, the cross-chapter thing that you've referenced, Steve, about, making a change here, how does it affect other chapters in the PDP with regards to Whenua Māori and what they're proposing. So, yeah, Mr. Commissioner, you asked about the cost. If you deal with it today, would that be better than the cost we've incurred? Well,
it's more that if we stop the process and it starts again, you're going to go through with the process.
If you're going to make any change to the status quo now, that'd be re-notified. That's, I think, the resounding thing. And
Okay.
yes, it'll be more cost.
Yep.
But if you were going to adopt the lines as cells, then we would ask that that be re-notified so that all the affected owners could come, because as we saw in the Uramahui land, there's one entity there that would love to be here, and probably a few other big Māori outfits that would love to be here, but they're unable to because they've been notified shortly. And it has a big impact on them as whenua Māori. I mean, my conclusion just is saying, as Kapatahi Corporation is a member of the Uramahui landowners group, we're endorsing the evidence of Mr. McPhee, the plan for Uramahui land owners, and also the resolutions or conclusions of that lay evidence of Uramahui landowners.
Thank you very much. Any questions?
No, I think that covers it off pretty well.
Nice.
Thank you very much.
I just mused at the comment that Tane made before about only being a layman, because quite often it's only the lay people that come along and make submissions or make presentations that are more effective than the professional witnesses.
It's pleasing to hear.
Sure.
We've got hope.
So Andrew's not going to give us a double.
I wasn't a comment on that. He has enough cheeky comments from me without that being taken as one.
Is it, Mr. Simpson, are you?
Yeah, I'm a bit worn out, to be honest with you, but we'll get started again and I think it'll be the finish of it. Yep.
So do I.
I can deal with that. I wouldn't mind, Rashida, if you could just flick back. I just want to make a comment on that. Flick back to where it shows that map of aerials. Yeah, there. You asked the question, Steve, about the double line and all the rest of it. That's a really good indication of what's actually going on in our area. If you can see it. Yes. Yeah. And then I'll say it again. Self personally, Mario and Errol all got double lines running through our properties and switches. Double lines everywhere. That's kind of relative to what my personal life. Check that too. Yeah. I've no doubt that would have read my original my evidence on my lay submission, personal point of view, the background of the families, which is in the area, and basically point out is that those poles were put there before we turned up. We turned up in 1981. I think they're relatively new at that stage. And the people that allowed them to go through would have had the viewpoint, and we had the same viewpoint when we turned up. That was for the benefit of the community and the area to go ahead. That's how people thought. I'm going to go back again. In 1992, stuff got privatised. So had a new set of regulations come. We accepted that. It was good. And we worked with it. And as far as I know, I'll say it again, there's never been any issues in that area with top energy, with access and maintenance, and requests to trim trees further back than what's actually required. Errol in particular, he's got a massive corridor running through his property. That's well beyond what's actually required by law. It's all being done. So now we're at the next stage. And we're going beyond the regulations of 1993. And as I've explained here before, I don't believe there's any grounds for it. We're actually getting taken advantage of, in my opinion. We're getting taken advantage of, especially by the mapping and what Top Energy are proposing. It's pleasing to see. I haven't had the time or energy to read your section 42 report, but from what I gather from the comments that Andrew made, that Top Energy's requests have been knocked back. Now, getting back to the view, you can see those poles up there. Those poles are actually on my property. They do this, they converge and like that, and they go across. They're everywhere. They recently required or asked of me to trim some trees back along my daughter's driveway. You can't really see it from there. You come down the road, there's this massive corridor. It's horrible. It's absolutely horrible. But that doesn't count. And if you go, once again, to my friends at Top Energy, you go back to the original submissions, 48351, should come up on the screen. They're requesting as a permitted activity to have a pole no higher than 25 metres, a cross member no wide, cross members no wider than 4 metres, and a footprint no wider than extending it by 300 mil. Now, that's not a true identification. The pole on the right-hand side, that is Waipapa. But if they got what they wanted, they would have a right to do that, or stuff along that lines, and we would have no recourse. Right. That is a serious upgrade. And they wanted that, and they were requesting that as permitted activity. That's a Waipapa as well, Mary. I'm assuming that's 110 kVA.
Yeah, I think it is.
Yeah, yeah.
Running through that industrial area.
Yeah. Andrew in his evidence has retorted back upon my request, because it's a second one. He's retorted back at Top Energy and put restrictions in which are actually in place in legislation, which is all new to us, because we're laymen. That's acceptable, but what I'm trying to point out to you, this is the intent of what they want to do by using the plan as an instrument to gain what they want, which is to override basic property rights.
Without a consent.
Yeah, without a consent, as Mario says. So that's really what I want to say. Yeah, and that's what you guys have to take into account. Because as we view it, we're getting taken advantage of.
Any questions?
Just a comment. Got the message. The impacts, land use, loss of properties, right, economic impact.
Yeah.
But I've come back to high order instruments, and I do wonder whether we need to include Te Turi Whenua, and the impact of the Maori Land Court on Maori lands. So we'll work through that. Thank you. Thank you all.
Thank you very much. Anything else from anybody before we? Okay, thank you very much. Thank you for your presentation. We're going to take an adjournment now, and we've got morning tea, and we're going to be out there, so you're quite welcome to join us. So thank you very much. Thank you. Huh? It's the council. We'll take it off your rates. I added to your rates.
Kaitāia at the door.
I just hope
Don't eat too many biscuits.
It's 10:54. So that's say 11:20. It's 11:20. So back at 11:20, guys.
But even the individuals, it's like the plan.
When we get a chance,
Yes. They can do that. I've got it.
Oh, okay.
I should have printed that this afternoon, but I don't.
They're going to have a whole. You want to?
No, I'll get it copied and I'll give it to you.
Thank you.
Thank you.
Oh, that was your old man. Oh, Gary, yeah, and he was just. As we're getting, as Aaron said, they're probably getting a bit nervous.
More aggressive.
Yeah.